So what's the Open and Public Meetings Act? It's the state law that ensures government actions and deliberations are openly conducted. Before we continue, keep in mind that this video is an overview, and exceptions may exist based on your entity type. So what's considered an open and public meeting? It's when a governing body majority meets to discuss or act upon government business. It includes the meetings sometimes referred to as workshops or executive sessions. Regular meetings, public hearings, electronic meetings, and emergency meetings are all open and public meetings. Open and public meetings don't include chance or social meetings. A public hearing is a type of open and public meeting where citizens have a reasonable opportunity to speak. Public hearings happen when a government adopts a budget or imposes or increases taxes or fees. An electronic meeting is a type of open and public meeting that's convened electronically, such as via phone or the internet. Remember, the governing body must adopt a resolution, rule, or ordinance allowing and governing electronic meetings. An open and public meeting may be closed to discuss any of the following: a person's character, competence, or health, security personnel, devices, or systems deployment, collective bargaining, litigation, purchase, sale, or lease of property if an open discussion would prevent the entity from completing the transaction on the best terms, investigations of criminal misconduct, and private or protected information per the Utah Procurement Code, including trade secrets. 2/3 of the governing body need to vote yes to close a meeting. Quick math lesson. 2 divided by 3 equals 66.7%. Let's say your governing body has 5 members. If 3 out of the 5 members vote yes, that equals 60%, which is not equal to or greater than 66.7%, which means you're 1 member short and instead need 4 out of 5 members to vote yes. During a closed meeting, a governing body can't interview someone applying to fill an elected position, discuss filling a midterm vacancy or temporary absence, discuss the character, competence, or health of a person whose name was submitted for consideration to fill a midterm vacancy or temporary absence, or approve any ordinance, resolution, rule, regulation, contract, or appointment. If a closed meeting is discussing a person's character, competence, or health, or security personnel, devices, or systems deployment, no recording or minutes are required. However, the presiding member needs to sign a sworn written statement stating such. If the closed meeting is held for any other reason, a recording must be made. Emergency meetings may be held to discuss an urgent matter due to unforeseen circumstances. In order to hold the meeting, the best notice that's feasible is provided of the time, location, and topics to be considered. An attempt is made to contact all governing body members, and a governing body majority approves the meeting. Entities that hold regular meetings need to provide notice at least annually of the year's meeting schedule. As always, the notice must include date, time, and place. For entities that don't hold regularly scheduled regular meetings, 24 hours notice must be provided. All meetings, whether regularly scheduled in advance over the course of the year or scheduled as needed, must provide no less than 24 hours notice of meeting agendas. If a public hearing is held, public notice requirements change. Make sure to distinguish between regular meeting notice requirements and public hearing notice requirements. For regular meetings, an entity is only required to notify a newspaper and doesn't need to pay to publish a notice. For public hearings, notice must be published in at least one issue of a newspaper. If a newspaper of general circulation isn't available, written notice is posted in 3 public places within the entity's boundaries. Regular meetings require 24 hours notice. Public hearings require 7 days notice. For both regular meetings and public hearings, written notice must be posted at the principal office of the governing body, or, if no such office exists, at the building where the meeting will be held. Governing bodies must also provide notice of open and public meetings on the Public Notice website at publicnotice.utah.gov. By posting on the website and providing the email of the local newspaper, governing bodies can also meet the requirement to notify a newspaper. However, other requirements such as publishing in a newspaper still apply. Typically, posting on the Public Notice website is done by the records officer, recorder, or clerk. However, it's the governing body's responsibility to ensure notice is provided. State Archives has prepared a training manual and quick guide for owners and posters, as well as training videos that can be accessed at their website at archives.utah.gov. If your entity is increasing a fee or undergoing truth in taxation for a property tax increase, be aware that there are additional notice and posting requirements. Public meeting agendas need to include reasonably specified topics to be considered, with each topic listed under a separate agenda item on the meeting agenda. The governing body may not consider a topic in an open meeting that wasn't on the agenda. If a new topic not on the agenda is raised by the public during an open meeting, the governing body may discuss the topic. However, final action may not be taken on the new topic during that meeting. Meeting minutes and an audio recording are required for all open meetings, with limited exceptions. When an open or closed meeting is required to be recorded, it must be unedited and contain all the portions of the meeting. Recordings of open meetings must be made available within 3 days. Every entity needs to establish procedures for the governing body's approval of minutes. Pending minutes are written minutes prepared in draft form and are subject to change before being approved by the governing body. Pending minutes must contain a clear indication, such as a draft or pending watermark, that the governing body hasn't yet approved the minutes and that they're subject to change. Pending minutes must be made available within 30 days. Approved minutes are written minutes of a meeting that have been approved by the governing body. Approved minutes are the official record of the meeting and must be made available within 3 business days. Whoever is responsible for taking the minutes during meetings, typically the records officer, recorder, or clerk, needs to be familiar with what OPMA requires be contained in the minutes. When a governing body closes a meeting, the following must be publicly announced and entered into the minutes of the open meeting at which the closed meeting was approved. The reason or reasons for holding the closed meeting, the location where the closed meeting will be held, and the vote of each member of the governing body either for or against the motion to close the meeting. The recording and any minutes must include the date, time, and location of the meeting, the names of the governing body members present and absent, and the names of all others present except where disclosure would infringe on the confidentiality necessary to fulfill the original purpose of closing the meeting. For more information, access our local government resource center at resources.auditor.utah.gov.